Often when we settle a case, we have to have a really difficult conversation with the client when they realize for the first time perhaps that you have to reimburse your health insurers for expenses that they paid. A lot of times they'll call and say, you know what, I paid my premiums for years. Why on earth should I have to repay my health insurance company? But unfortunately, that's the reality. That's state law, federal law, and it's also language that's included in many health insurance policies. Some health insurers, especially those large group plans, actually have stronger rights than those that are smaller plans. It depends, I mean, it varies from insurance company to insurance company, but generally speaking, probably 95 to 98% of the health insurance companies have a right to be reimbursed from your claim. And so it's just a reality that we need to deal with. We deal with that in a lot of different ways. The first step is actually to figure out, do they truly have a right of what we call subrogation? And so we have to get the policy language from the health insurance policies. The next step is to look at what they actually paid. Go through it. You know, if your claim involves a brain bleed as a result of Xarelto and they have charges related to when you broke your toe, those aren't claims that need to be reimbursed out of your Xarelto settlement in the future. So what we need to do is minimize the amount of expenses that the health insurance company can even claim as a starting point, and then at that point we can engage in negotiations with them. Generally, if it was a single injury claim, we would negotiate directly with the health insurance company, or with, a lot of them have kind of third parties that negotiate their claims, kind of like bill collectors. And we could, you know, engage in a back and forth and often are able to reduce those liens. In a mass tort context, however, we often deal with these issues in a very different fashion. And it actually provides a greater deal of savings for the clients than if we were engaged in one-on-one negotiations. What generally happens is we actually will retain a third-party lien administrator, which is a company that has expertise in these types of litigations. They will put all of the claims together, and they'll actually go to the various health insurers, usually starting with Medicare and the various state Medicaid agencies, and they'll actually negotiate what they call a global model. And what happens is rather than the agency spending the time and effort or paying someone to go through all their records to figure out what claims they paid for a particular claimant, and all the back and forth that we'd normally do on a one-on-one case, what instead happens is the third-party lien administrator comes in and says, look, this particular litigation, say it's a hip implant litigation, involves these types of injuries. This is generally what you would have paid under your contracts for this particular type of claim, and then based upon that they can negotiate a model for how much should be reimbursed. They also will provide the names of the claimants that have cases that are being settled, and so there's a great amount of administrative savings for the governmental agency or for the private health insurer. And so based upon those types of negotiations, the amount to be repaid to Medicare or Medicaid, for instance, would be far less than what was actually paid on behalf of each of the clients. In addition to that, that same kind of modeling of claims reimbursement has been carried over to the large health insurance companies. Many of them have banded together and are negotiating as a block with the various lien administrators with regard to mass tort settlements. So again, we're able to see substantial reductions in the amounts that are being repaid by plaintiffs as opposed to what we would expect on an individual case.